And joining us live in studio, Adil Chabeleng is Transform RSA President. We have Tsepo Khadima and Botswang Muilwa, political analyst. And via Skype, Mr. Carl Niehaus, MKMVA NEC member. And that's via Skype, rather. And Marinus Vickers is the constitutional lawyer and expert. Good evening to you, gentlemen, and thanks so much for joining us. Is there moral victory, as we heard from UDM leader General Bantu Olomisa, that the ANC now, I guess, has to act, or rather vote according to their conscience? Is there moral victory here?
Well, there is nothing in the court, the judgment as handed down today, that suggests that, in fact, the members of the African National Congress can now vote in a secret ballot following their conscience. Effectively, I think what the court did today was to give us a Henry Ford moment. You can have any color you like as long as it's black. So when you take into account, when you read the judgment, particularly paragraphs 57, 58, 59, and then again 63 and 64, and you read in conjunction with paragraph 80 of the judgment, and you take into account where effectively the Constitutional Court has prescribed the conditions under which, if the Speaker is to make a decision to vote by secret ballot, those considerations are a mountain to climb. And the effect of those considerations that have to meet a test is such that it will be impossible to satisfy them in the event that the Speaker decides to vote, say secret ballot will be the method of voting that you have. For example, we know that the opposition parties, particularly the EFF and the DA, have for a long time boasted that they have got somewhere between 70 and 80 members of the African National Congress who would vote with them, but they would keep their own members. Now, the Constitutional Court says that the Speaker has to consider, amongst others, that there should be no risk of bribery and corruption, whereby members of parliament might be induced to so-called vote with their conscience when effectively they are doing so for monetary gain. And when you take into account one of the tenets of the Constitution being transparency and accountability to the citizens, it would be a mountain to climb once again to satisfy that, to say, well, it is in the interest of the electorate who, after all, they are the affected party, and you can't now go that route without recourse to them. So those considerations are a mountain to climb, if anything. Hence, I'm saying this is a Henry Ford moment. You can have decide the method of voting whichever way you like, as long as it's open, because transparency to satisfy that. There can be nothing transparent in a secret ballot. Yeah. So that already it just simply means that it is the end of the road. Now, should the Speaker somehow misunderstand the effect of the judgment and go and say, I'm hereby deciding that the voting will be by secret ballot without first and foremost meeting the requirements as in terms of those considerations, we are going to see more litigation before the Constitutional Court, and I think we'll be in court for the next 2 years. All
right, let's get Mr. Carl Niehaus's response. Good evening to you, and thanks for joining us. And the Chief Justice emphasizing the accountability and transparency imperatives in the voting, and also calling for courage within the members of the ANC in Parliament. Why would we have needed a secret ballot in the first place, besides as an inducement or something that was brought about by the opposition?
Well, I think, first of all, we must welcome the decision by the Constitutional Court that it is really the decision of the Speaker of the National Assembly and not for the court to decide about this. So that is a good decision, which takes us away from the usual process that we've seen in the last while, where our courts have been overreaching themselves and we have been having judicial overreach time and time again. So this is good for the courts. It is also good for the National Assembly, and I believe it's generally good for South Africa. I can't really understand what the official opposition, the UDM, and the other opposition parties have been trying to achieve with this so-called secret ballot. Because ultimately, as President Zuma pointed out in Parliament today, it is expected of all members of the African National Congress to vote in accordance with the ANC's party line. And the National Executive of the African National Congress has spoken very clearly about it. At the last NEC meeting, it issued a statement saying that all members of the African National Congress, in terms of its own rules and its own constitution, has to act in line with the policy positions of the ANC, and there's also a caucus decision that says that members of parliament will not vote in favor of a no-confidence vote. So whether this decision was for or against a secret ballot, we were still going to have the same final effect, and that was that the ANC members of parliament will vote against a no-confidence vote. But the important thing that we see today is that we now have the court clearly stating that it cannot enter into this area because it falls outside their jurisdiction to prescribe. That is a good thing for South Africa, and it is good for our democratic processes.
All right, please stay on the line. A response from Mr. Nchabeleng and Botsang. Good evening to you. We hear the opposition perpetually saying the ANC will be punished. There's an opportunity now to do right by the majority voters or South African citizens. Put it into context what this judgment means with regards to a motion of no confidence, or rather a secret ballot.
Well, thank you so much, Cindy. And good evening to our viewers at home. The key issue here is there has been a victory on the side of the ruling party. Opposition has lost out completely because, if you recall, UDM put this application to the Constitutional Court requesting that the Constitutional Court must make a decision to allow for a secret ballot. And because some of these political parties, and particularly opposition parties, are quite unaware of how processes work, and they have not even done their own thorough work. I mean, they should have known before even approaching the Constitutional Court that there is no way that the Constitutional Court has the ability or within its remittance powers to can instruct that Parliament must take on an executive role of that nature to actually offer a secret ballot. But in this case, UDM has lost because they had put an application which had failed, unfortunately. But in this case, it's the state again that must subsidize the failure of another opposition party's attempt to literally just delay democracy. This is not the issue that should have actually went to the Constitutional Court. But unfortunately, because of the fact that we're living in a democratic state and a process, some of these things needs to be tested. All that the Constitutional Court could have done was just to give an arbitrary view.
Cindy, good evening to you and my fellow panelists. You know, Nchabeleng just wrapped it up. Tsepo says there's a mammoth task in front of them. There's a mountain to climb. I think there's a marathon to run. This matter is going to run into court for a number of years to come. But Mr. Kalni has said something very crucial to say. He's wondering what did the opposition intend to achieve by going to court. I will tell the nation what did they intend to achieve. They had wished that the court will rule that the Speaker of Parliament must force the secret ballot, which is not true. That's not the case. I asked people this afternoon when I saw the news to say, but what is the excitement amongst the opposition? Because they have literally actually failed in court. The ruling party has become victorious because the court has actually thrown this matter back to the Speaker of Parliament, who happens, unfortunately for the opposition, to be the chairperson of the ruling party, and she's not in favor of this. But what went wrong with the Speaker of Parliament? And I'm starting to question what we call state law advisors to people like the Speaker of Parliament and the President in this case. Now, the taxpayers must incur costs towards legal costs. What went wrong is, I do not know, and I said it on this platform, how on earth did any politician or legal advisor expect the Constitutional Court to rape the constitution of the country and rule against the prescripts of the constitution? It was not going to happen. I do not know why did the Speaker of Parliament, in responding to the application, said she does not have the powers to can determine whether it should be a secret ballot or not. She does. But the constitution is very explicit. It's very clear on the circumstances which she can opt for a secret ballot Now the Concord has gone back and said, Speaker, you do have those powers. We knew this. We expected this to happen, to say the Concord will come back and say to the Speaker, you do have those powers, but here are the prescripts and the circumstances in which or under which you can opt for a secret ballot. It's a wait-and-see situation if Mbete is going to betray the organization that she belongs to, the organization that it has deployed her, and opt for a secret ballot. We have to wait and see. So there's two options that are still at hand. The Speaker of Parliament may sit down and say, I do not see and I don't have sufficient reasons at hand to can authorize a secret ballot. Even if she authorizes it, the second element is, will the more than 220 ANC MPs vote against their party? It's a wait-and-see situation. That's why I'm calling it a marathon.
Yeah.
Cindy, I mean, look, effectively, the Speaker of the National Assembly is not a member of the African National Congress or any political party in that capacity. Yeah. And the judgment, by the way, is very clear. In fact, it requires of her to be impartial, to not take into account her political party affiliation. Because if she does so, in deciding on whether or not we're going to vote by motion of no confidence, in fact, she'll be going against this judgment. But what the judgment further sought to do, or has actually done, was to now conscribe the circumstances under which she can say, yes, there is a motion of no confidence. Now, when you look at the materiality test and the objectivity test on those conscribed circumstances or conditions, is such that it's going to be absolutely impossible. For example, she would need to demonstrate that the risk of any member of parliament being induced or bribed or corrupted to vote in any one manner, regardless of which political party they belong to, that risk is not there. And also she has to again show that if the motion of no confidence will indeed, one of the basic tenets, which is what? Transparency and accountability to the electorate or to the citizens, that everything else must be done what? In open. The secret ballot, unfortunately, cannot have the effect of enhancing one of the tenets of our constitution, which is transparency. So therefore, it means that it will be a mission impossible for her to even say, yes, in this circumstance, because it's on a case-by-case basis, in this circumstance, we must vote by secret ballot with those conditions attached. Those conditions effectively exclude, whether people like it or not. If you go and you read them carefully, and the paragraphs I've cited of the judgment, you will notice that indeed she has effectively been channeled to say, for transparency, it must be open, and particularly paragraph 80 of the judgment. Yeah,
Mr. Niehaus, would you say that is the most important judgment, or part of the judgment that we can take away? In the interest of transparency, there cannot be a secret ballot, because if you stand by your convictions as a member of any political party, you can do that in the daylight, what you would do behind closed doors.
Well, Cindy, I think you've hit the nail on the head. The members of parliament are there on behalf of their various political parties. So are the ANC members. If you're there as an ANC member, you're going to vote in line with your party position. And I really think that the opposition are hypocrites. We know ourselves from previous experience that all of them have constitutions and rules that says that their members, as members of parliament or other legislators, are not allowed to vote according to their conscience, are not allowed a free vote. If they dare to vote against the position of their particular party, they will immediately be disciplined and they will probably be suspended from the party. Now, why must the ANC have a different set of rules or behave differently from what these parties do? Just recently, we had the Democratic Alliance saying that if any of their members vote in a legislature or in a municipal council that goes against the position of the party, that person will be disciplined. So the leader of the opposition is an absolute hypocrite when he now goes onto air and tells us that ANC members should vote again with their own free conscience, as if their conscience is not aligned with their political affiliation and their understanding of the situation in South Africa because they are members of the African National Congress. Now, honestly, I cannot see how we're going to move away from that situation, that everyone will do that.
Sure, let's just test the constitutionality of it all with Mr. Marinus Vika, constitutional lawyer. Good evening to you, Mr. Vika, and thanks so much for joining us. We saw in the Mogale City a mayoral no-confidence vote where the DA is now instituted lie detectors, to find out who the traitor was, as it were. And yet they're calling for a secret ballot within the African National Congress, as Mr. Nihau saying that very glaring contradictions in how we apply the law. In your view, the Constitutional Court making a fair judgment?
I'm listening to this debate, and there are many political arguments and considerations. But the constitutional issue is very simple. What the court has said today is simply that there is a possibility, and it is incumbent, and she has the discretion, the Speaker, to ask for a secret ballot. That is a very important new constitutional point. Under which circumstances she should exercise her discretion? Well, they've laid down some guiding lines, but they're not imperative. She has her own discretion. But what is important in this decision is that in future, and we mustn't look at the present state of affairs, we must look at the present. It could happen in future that discretion will crop up again, whether the Speaker can ask for a secret ballot. And that's a very, very important extension, or I see it as an enrichment of our Constitution. So yes, there are many political considerations. Now, I just want to say, if somebody joins a political party with the discipline of the party, that is an act of conscience. You've got to live with your conscience, and once you're a member of a party, then your conscience would dictate that you follow the rules of the party. That is party politics. It's in our history. Now, if you're not happy with what the party tells you, well, you can vote, or I think, in this case, and I don't want to join the political question, that there are some members who are going to abstain. But it will be if the Speaker decides to have a secret ballot, and it seems it's very likely, because she has now, in terms of the judgment, she has that authority. Then it's for her to use these guiding lines of the Constitutional Court.
Mr. Vika, just very quickly, so if the Speaker, for argument's sake, decides that there will not be a secret ballot, is her discretion absolute, or can we anticipate that she will have backlash because the desire from the opposition was such that there'd be a secret ballot with the hope of a different outcome?
Yes, well, the opposition would be furious, but that's a political question. She thought the opposition can't run back to the court because the court said she has a discretion. So the opposition, of course, they'll be furious. They'll cry out and so and say she's been under the influence and she's acting in a party political capacity. But that is still her discretion, and that's the gist of today's judgment.
Can we put the matter, please stay on the line, Mr. Vika, this matter of the no confidence to rest based on today's judgment?
I don't think it will rest. They are going to hammer on Zuma must go until 2019. It is not going to rest. They will go back to court and try other avenues. But when the UDM filed in court, Cindy, I said exactly what Professor Marinus Vika is saying. We must be very careful, and the opposition is not being smart. They must be very careful that this will come and bite them in future when they are in power, because they are fiddling with a constitutional position whereby there will be a judicial precedent. Now, lately for South Africa, there is no precedent because the court has thrown back this to where it belongs to the Speaker. But there's another element that none of us has not been bringing into power. None of the African National Congress MPs who have the opposition have self-appointed themselves to be their spokesperson has come up and said, I am fearing that if I vote with my conscience, I will be disciplined with my party. None of these MPs of the ANC has approached the Speaker of Parliament or any other institution to say, I am scared and I am not voting with my conscience or in in confidence when we vote openly. Not even one. You will need, one of the elements that the court has put into place today is that the Speaker of Parliament will have to take into consideration the position of those MPs. It is not said in those ways, there's the ways that I'm using, to say those MPs, we're in a constitutional democracy whereby not their names are voted into those positions. The voters or the electorate votes for the party decides to deploy those people. None of them has come up and said, if I vote against the president or the Speaker of Parliament, the wishes of the ruling party, I will be disciplined. You will need that. You will need them to come up.
I mean, the bigger question, obviously, it would be the servitude to the South African population and what this judgment means in upholding the democracy, the constitution, accountability and transparency as well, Adil.
Yeah. I mean, just let's go back to the real issues here. You have opposition parties now demanding that a ruling party, members in parliament, must vote against themselves. I mean, this is the most bizarre thing ever. Where have you ever seen in the world where a opposition party pushes a motion, distracts the whole parliament's time, takes the whole process unnecessarily right up to the Constitutional Court to be told the same rules that they said that the Speaker has the discretion to make the decision in terms of open or secret ballot. Then you go back, they start meddling on the issues to say people must start voting with their own conscience. The same principle does not even apply in their own political parties. Some of these opposition parties do not even have members who are given the opportunity to vote with their own conscience. Let's go back to the applicant situation in this case. UDM. What has UDM done since being in parliament all these years? You have a one-man party who runs around by himself within the party that he has, 2 or 3 of his members, and completely causing chaos for everybody else to be halted. And General Holomisa has not been able to prove anything. This is the best success failure he's ever achieved. Bringing a motion to the Constitutional Court.
I'm going to read an excerpt from a response from the Democratic Alliance leader in response to the judgment handed down by Chief Justice Mogoeng earlier on. It says the motion of no confidence in President Zuma is a pivotal moment for our country and its future. Jacob Zuma has abandoned the interests of the people, the economy and South Africa in favor of a kleptocratic Guptamocracy. We cannot allow this to continue any longer.
Yeah, what we maybe need to encourage the leader of the opposition is to approach Oxford Dictionary for them to include that new term he just come up with. Yeah. I think maybe that might be the only value we derive from what he said. But if you look at paragraph 81 of the judgment, by the way, where it says that nobody, including members of parliament as well as members of the judiciary, you cannot say that they can't be bought. And that inducement, that risk of bribery is an ever-present risk, particularly in our current context. It therefore means that you cannot do anything in secret. When we look at the tenets of our constitution, which is what? Openness, transparency, and when you take into account the risk of the members of parliament, or even as the Chief Justice himself agrees that even a judge could be bought. Of course, there are remedies in the event that judges can be bought, but he's saying that they are not immune from being bribed. Therefore, with that ever present, and as read in the judgment, I just cannot see how anybody can now hold course on demanding that it must be by secret ballot. No, I cannot even see how the Speaker, by the way, will be able to satisfy the mitigation of that risk. The other question that I have is that, well, will the National Assembly perhaps now take a step back and start to reflect on that the motion of no confidence has got the effect of collapsing one branch of the state? We are in a trias politica. All 3 branches of state have got equal powers of overlooking each other. In this case, the manifestation or the coming about of the legislature as well as the executive is through a vote in an open democratic process. How can it therefore be that the few members of parliament who have been entrusted can therefore go and betray the trust of the electorate by now acting in a manner that perhaps he's got no recourse to the people that elected them in the first place. Maybe there's a need for constitutional amendment in that regard, so that that section 102 is more refined to give recourse to the electorate. Let the electorate be the one that say we have lost.
The National Assembly has been created as if they're there on their own volition, if you will, representing their own interests, and can decide in whichever way that their conscience leads. But they are representing the voters and accountable to the voters.
Yeah. If you recall, a few months ago, there was a major issue and a complaint that actually the courts in South Africa have conferred unto themselves the powers of being literally the leading and ruling party, that there was a judiciary overreach. Today, that issue has been set to clear and has been resettled, because the court have just said to the applicant, which is the UDM and the supporting opposition parties, that from now onwards, if matters of this nature arise, find ways within your own structures to settle them without actually wasting court's time. Because,
also, Cindy, what we should recall is when the court speaks to these political parties, it doesn't talk to them as individual and opposition parties. It speaks to them as people who are representatives of the public in Parliament. Let us recall what Chief Justice Mogoeng said during the process of this application. He actually laughed at them when he actually interpreted to Advocate Dalimpofu at that time that if we go through this process, are you aware that the whole executive authority will have to collapse if the president has been removed from the position? And they said, but what do we do in the meantime when the whole executive authority collapse? There will be chaos in the country and all that. Now, all these people, we are not saying they don't have a democratic right to can go and try and remove the sitting president. No, they do have the take part. We are saying you cannot illegally and procedurally adjust or augment the constitution in order to suit the excitement of the opposition parties of today. We cannot run the country like that. What if in 2022 the EFF is in power, or the DA, they've got a sitting president, and we don't even have to go to court, we don't have to follow the constitution. We refer to what transpired in 2017.
Before I lose this train of thought, sorry, Botsang, just from a constitutional point of view, Mr. Vicker, in that President Jacob Zuma has been portrayed as a perpetual violator of the Constitution, and this stem, of course, from the Ngandla matter and now allegations of state of capture. Is it constitutional, though, to continue saying, even if he's atoned and, went with the remedial action from the erstwhile public protector to pay back the money, to perpetuate this stigma of him having violated the Constitution?
Yes, but that, again, is a political question, a highly, highly important political question for Parliament to resolve, whether in a secret or an open ballot. It is not for the court to transgress the separation of powers and to say, we're going to step in, one day you'll see, we'll walk into the Parliament and we'll tell them what to do and not to do. That's not the position or the function of the court. The court has to control the unlawful action. But here is a highly inflammatory, highly important political issue that's got to be sorted out by the political parties, by members of the political parties, whether their conscience will agree to vote according to the tenets of the Parliament. But it's not for the court to run the political game. As much as we feel, and many people feel, that the motion of confidence should be in secret ballot and so on, and that the president's not doing a good job and so on, that is something to sort out in Parliament. And also, don't forget, it's got to be sorted out in the media. That is part of the political process. The courts cannot become rulers. They must be controllers, protectors of the Constitution. And as I said, they've given the judge gives some clear indication what the speaker should take into consideration. But finally, it's still her discretion.
All right, Mr. Vicker, just stay on the line, please. We have Mr. Niehaus, and I'll quote again from the response from the Democratic Alliance, and it says, for the sake of the country, it is important that members of Parliament, regardless of political affiliation, come together to put South Africa first by voting to protect the Constitution and to end corruption. So what you read out of that, Mr. Niehaus, is in a sense almost an electioneering slogan that the ANC hasn't been able to rebut effectively.
Well, Cynthia, I think the leader of the official opposition has even outdone himself today with all the hot air that he's been sending up. We could have sent a couple of hot air balloons up with all of this. But at the end of the day, it boils down to a very simple situation. The African National Congress is the majority party in South Africa. The majority of members of parliament are ANC members. They have been placed there by the ANC. The vast majority of voters in South Africa voted for the ANC. President Zuma is there as the leader of the African National Congress, as the president of South Africa. That is the democratic reality. And the Democratic Party can tell us all about conscience. They can tell us all about all these so-called moral issues that they try to raise. But the fact of the matter is that we have a running, governing democracy. That democracy has put President Zuma as the president of this country. Today, President Zuma told us 7 times there's been votes of no confidence brought by the opposition parties, trying for them to undermine the democratic process, abusing the legal process, abusing our courts, trying to govern and rule through the courts. Now, truly, I hope that today's decision by the Constitutional Court will bring an end to these spurious processes that the opposition parties bring to court to try and govern through the courts. They need to be given a lesson that there are separation of powers, that they have to accept the outcome of the democratic processes that we've had in South Africa, that they cannot overthrow our democratic processes by going to the courts. And the other point that needs to be made is that our courts have to put their foot down and say, we will not be used and abused in this manner by minority parties who haven't managed to get the vote from the voters and now try to use us to try and govern. It has to come to an end,
all right,
and I really hope today will bring it to an end.
Mr. Niehaus, so you agree that this is an attempted coup d'etat via the courts, by the opposition?
They are trying to
It's an attempt.
coup, what we will call a legal coup, but unfortunately the Concord for the opposition was not allowed to be abused in this instance. There's something also, Cindy. The opposition, particularly the EFF leader and the UDM leader, and COPE, they stood up and said, we know we have ANC members and MPs who will vote with us, who are prepared to. If you are so confident that more than 70 ANC MPs, as Tsepo alluded to earlier on, that more than 70 of them are genuine, they are anti-corruption, they don't want President Zuma, and they will vote with the opposition, why don't you put it in the public space in order to win votes of the electorate, to say even those that the ANC had deployed realize that the ANC is not the correct wagon to can lead this country to where it wants to be. If you have more than 70 people who are prepared to stand by you, you go to the media and say, I've got more than 70 ANC MPs who will vote by me. Why do you want those MPs, if they're genuine, if they're truthful, why do you want them to vote in secret and not in public?
We'll get back to that. Just in case you're joining us for the first time, this is Africa News Network First Fast Live, and this is ANN7 Prime with me, Cindy Mabi, and our panelists reflecting on Chief Justice Mogoeng and his team in the judgment, essentially saying that the Speaker of Parliament, Ballot Mbete, has got the discretion to decide on the voting procedures. Now, meanwhile, the ANC caucus welcomed the Constitutional Court outcome and remains resolute that none of its members of Parliament will vote with the opposition when a motion of no confidence is tabled.
The political parties did approach the Speaker and wanting an urgent motion or vote on this motion of no confidence, and the date was set. That date was the 18th, if I'm not mistaken, of June. All of us had to come back, but after that, that date was then changed again through the political parties who said that they have now gone to the Constitutional Court to request the Constitutional Court to look into the question of secret voting. How Parliament works is that the Speaker needs to come before a multi-party forum called the Rules Committee. It is in that multi-party forum where decisions that affect the working of Parliament are then taken through consensus. Now, I am not totally in agreement with any notion that the Speaker has any discretion on this matter. In fact, the discretion that the Speaker might have, it is as far as she can convince the Rules Committee that this is a right way to go. That's where her discretion ends and starts.
The decision by opposition parties and friends of the court was a fishing expedition. It was clear from the beginning that the application, or the applicants and their application was frivolous and vexatious. If you look at the relief sought, they wanted the court to direct another arm of state, which is in this case the Speaker of Parliament, in terms of what is defined, both in terms of the Constitution and the rules of Parliament. Very clear, the Concord refused to be brought into or to be used by opposition to co-govern, because it was important that they must also defend and protect the separation of power doctrine, and they've done so quite very well.
And we're joined in studio by Adil Nchabeleng, Transform RSA President, Tsepo Khadima, and Botsang Moilwa, political analyst, Carl Niehaus, MKMVA NEC member via Skype, and Marina Savikas, a constitutional lawyer. And thanks you at home for staying with us. You were talking about a soft coup. What do you mean, Adil?
Look, this application to the Constitutional Court was actually an attempt to bring about a soft coup. Why would you take a matter and request the Constitutional Court to deliberate and actually declare that the Speaker must allow for a secret ballot? There has already been caucuses among some of these opposition members, including some members within the ANC. And as a result, all that they wanted was an instrument and a mechanism that allows for this process to be carried out without even hindrance. Because if it had been done without going through this motion and process, it would have been seen as a direct, really takeover of state power and taking away from the ruling party. Here we have a situation where you have a very spoiled opposition. They want to behave like they are in control and in actually the ruling party's position, whereas they are not in the ruling party's position. They are a minority, they are an opposition party, for particularly that reason and sake, because the people have not placed confidence in them as yet. Until then that they have such powers, they cannot be dictating and continuously taking democracy break. We as Transform RSA, for instance, are looking at the development of this situation and this entire political mayhem. And we're asking ourselves, where is the interest of the South Africans at heart? Here you have political parties who are toying with a democracy, who are toying with the state time and people's time, when we are almost in a situation where we have been given a downgrade in the country, where we should be looking at radical economic transformation. We have a crisis on the land issue, which has not been attended to. We have economic issues that are currently hindering our progress going forward, and we are not attending to them. And here you have opposition party wasting our time, running around between courts for a motion which there isn't really much of an effect.
You know, Cindy, I wanted to come and say, for one of the few occasions I will agree with the head of caucus of the ANC, Mr. Mtembu, when he says, even after the Constitutional Court ruling of today, there's committees in Parliament. The Speaker of Parliament cannot just also depart from a normal practice and process that she follows. If she has to depart from a normal process that she had applied the last 7 times when this motion was filed in the last 9 years or 8 years since President Zuma has been in power, she will have to consult a committee of Parliament. She will have to consult a rules committee of Parliament to say, I am going or I'm thinking of applying my mind differently from a normal course, from a normal practice, and as the prescripts of the constitution of the country. Therefore, I'm consulting. And you look at the composition of that caucus, that parliamentary committee on rules and regulations. Again, it is being dominated in accordance with the demographics of the number of seats the parties have in Parliament. So we are actually wasting time as a nation.
But I mean,
instead of focusing on issues that will bring the economy, equitably shared amongst the population of this country. We've got the mining charter at the moment, which is much more important than trying to focus on Jacob Zuma. And I think the opposition, if they want to win votes come 2019, they should be focusing on very important things of this country than this Mickey Mouse game that they're trying to play.
All right, let's talk about the political, or rather the parliamentary procedures together with the judgment and how it empowers and protects the Speaker, because either way, if she does not use her discretion and apply the secret ballot, which we know is an option that she can exercise based on the prescripts that were outlined, if she does not do that, she will be subjected to further criticism of being partisan and not independent.
Well, I mean, apart from members of the African National Congress in the Rules Committee directing as empowered so by Section 57 of the Constitution, and then the Speaker elects to exercise her discretionary powers in deciding this. As I say, the judgment today effectively prescribed the circumstances under which she can bring about a secret ballot. Now, if you go and you read, and it's important for the viewers to get hold of the judgment and go and read particularly paragraphs 80 to paragraphs 83. Those paragraphs are fatal to the desired course of action or desired outcome of the opposition parties that are campaigning for a secret ballot. If you go and you read it, for example, the court is very clear that the consequences, adverse or injurious to an individual, cannot trump the interest of the electorate and the interest of the citizens, and you have to act in the best interest of ensuring what democracy is alive and well. Now, when you take that into account, and also that this cannot be either a fear or a money-inspired shame, but it must be a genuine motion of no confidence which is purposed and designed only to advance the constitutional values of service delivery, of ensuring that the country can be able to move forward. It is absolutely, therefore, unfortunately, limiting even that discretionary powers that the Speaker has, that she will then have to, on balance of all of this, she will effectively be limited to saying the voting is as customarily has been, that is open ballot instead of going secret ballot, because the risks in an in a secret ballot rather, have been well articulated in the judgment, and those risks are that much higher. As I said, they are a mountain to climb. Is going to be the easy road. The smooth path is going to be that of saying, let us keep matters as they have been. Customarily, we have voted in an open process. That's to enhance the constitutional values of transparency, of accountability. Yeah. Therefore, let's continue.
Yeah. Mr. Vicker, just again on the constitutional aspect of it, where Chief Justice made it clear that the consideration needs to be made on the risk associated with a decision of either a secret ballot, in this case, the lack of transparency, as the panelists alluded to. How significant is this point?
Well, it's very significant. He just warned. These are, as I said, not prescriptive. He just looked at the whole matter and he said, look, there are dangers on both sides and so on. And, you know, for the Speaker to decide, taking this into consideration. But I want to make a very important point. The final motion of confidence or non-confidence will reside with the voters at the next general election. So whatever happens in Parliament, we're back to the absolute basics of the democracy for the voters to say, well, it's failed, this motion of non-confidence is failed, but finally the voters will have the right, the constitutional right at the next general election to vote a non-confidence or a confidence in the present government. And that's not to be forgotten, that we must look a bit ahead. And, well, this is a bit of a, a sort of storm in a teacup, as I see it. But the important thing is that the Constitutional Court has said, and that is the really worth and the value of this judgment, that she has a discretion to ask for a secret ballot. And that could serve us as I've said, in future, if we're going to have other presidents, there'd be more motions of confidence in non-confidence in future, and then this judgment will stand up and say you have the discretion to ask for a secret ballot. That is the important aspect of this judgment.
Yeah, but the distinction to be made is that the court did not direct for a secret ballot.
No.
Per se, it just said the Speaker has the power to use her discretion to apply either or based on certain circumstances.
Contrary to what I saw in the media between 3 this afternoon and now, that they've created an impression. The mainstream media has created an impression, if you go to social media and read what people are saying, they've created an impression in the minds of people that the court has ruled in favor of the application of the opposition, that the Speaker of Parliament must allow secret ballot. That's not true. That's not what the court say. Let us be very clear and honest to our people. The court has actually said, Speaker of Parliament, the Constitution says the discretion lies on you to decide what needs to be done. And the Constitution has been very clear. We have sat there with Sepo and other analysts, Professor Siepe, and had said, but we don't understand why MPs and the opposition is going to court when the Constitution of the country is explicitly clear of what needs to be done, what are the powers of the Speaker. The mistake that happened, and the Speaker of Parliament must concede to that. That's why the Constitutional Court has ruled that she must pay the legal cost. It's for her to stand up in opposing the application and say, it is not within my powers to can make this decision, because that was what she said. What she could have said was, yes, the discretion lies with me, but I decide not to do what the opposition wants, or I decide to do what the opposition wants. Not to say she doesn't have powers to do that. So they've actually wasted money and time.
Yeah. But what choice does she have in not instituting or deciding on a secret ballot?
She still has a choice. Yeah. She still has a choice. She must take into consideration all elements that are mentioned. Sepo quoted from paragraph or clause 63 until 81 of the ruling. She still has a constitutional right to go back to the Constitution and read what the Constitution prescribes in when can a secret ballot be allowed. And I'm saying, Cindy, it will take months, if not years, to come to that conclusion, because she must take into consideration a number of legal elements, not even the politics, not even the political party that has deployed her. She must take into consideration a number of elements to say, these people who are in Parliament, we have parliamentarians receiving or parties receiving what we call constituency allowance or monies. That is a clear, simple sign of saying, MPs, this is not your money, it's not your salary. It's the monies that you must use to go back to your constituencies, to go and check if you are applying what they've put you to do there. So it's a process.
You talk about processes, and also subcommittees, oversight, etc. Why in the first place would the Speaker then say that she does not have the powers to make a decision on secret or open ballot?
Yeah. But remember, the Speaker was being forced to make a decision against their own will. If we go back to the reality and the truth of it, why actually UDM went on made an application is because they could not get their way in Parliament to force the hand of the Speaker to actually do a secret ballot. And in that case, they overruled the Speaker and said, we will go and actually get this matter aired out with the Constitutional Court. But now there comes another situation. Boyza has just indicated that you have a opposition party which has tendencies by which whatever judgment that arises out of the Court, the Constitutional Court, they tend to misinterpret it from time to time. It's not the first time where an impression and a narrative is created that the Constitutional Court has made a decision to say this and this has happened when it's not actually a fact. The Constitutional Court has even come out clear in some of its judgment to say if political parties starts giving a misinterpretation and peddles out there a misinterpreted version of what the Constitutional Court has done, it is tantamount to actually breaking the rules. And it is literally on a level whereby they are misinforming the public and it's criminal in its own sense.
Yeah, so, we understand that these obviously, every motion of no confidence would have to be ventilated on its own merit and for the Speaker to apply her mind in consultation with the other substructures. But we also, the judgment was said that she must make a fresh decision if based on the secret ballot.
That is to satisfy the opposition party as well as balance the whole process.
Yeah, so what is a fresh decision? Is it a new decision? Is it one in favor of secret ballot, or is it?
I disagree with Nchabele on this matter. She did not make a decision. The Speaker of Parliament, and she has to concede to this, she could have said, yes or no, I'm allowing a secret ballot. And she did not. She did not say no, she did not say yes. She said, I'm not going to entertain that. That's not. And she could have said to the opposition, I've received your application. I am declining, your request to can have a secret. And she did not do that. And that's where they fail us.
Well,
No, the hand was being forced.
The
she could have put the
Constitution
constitution.
was being forced. I mean, let's be honest and fair about it. She said, look, I am not going to allow for a secret ballot.
Okay.
And they actually insisted that she must do it.
Yeah, I think what maybe would worry people like myself perhaps is what the court said, that she misunderstood the effect of the Kawama matter, which was on similar grounds. That in this case, maybe she didn't have those discretionary powers to decide when in fact she did so. So indeed, I think Buzang is quite correct. She could have at that time in her pleading said, yes, I do have the power, or in her response to UDM at the beginning, we would have avoided going to court. Now we ended up with the Constitutional Court being burdened and being put in this invidious position where they would have encroached on the separation of powers principle in a matter that clearly the national Speaker of the National Assembly, so legally advised, could have understood that, yes, I have got the powers constitutionally and I have exercised my discretion. Because in her misunderstanding of that effect, that she's got the powers, we now end up with this clarity that is coming with a whole package of many other considerations that before, by the way, we didn't know about. And I'm saying it is those considerations that now unfortunately have now put, it's going to be a heavier burden for her to discharge, that I have met those considerations in now deciding that I'm going for a secret ballot, because that is what the UDM's main course of action was to say the Constitutional Court must direct the National Assembly to vote by secret ballot. And puzzlingly, the Constitutional Court, on that main course of action, they have remained silent, except to say, let the matter go back to the National Assembly and let the Speaker deal with it. And I think it is a worrying, again, that the Constitutional Court here has burdened us with a judgment that maybe it might need to further be clarified. And it's not the first time we are seeing this coming out of the Constitutional Court, by the way. We have seen even previously on the CPS matter, that again, the court had made a decision that further seeked or needed to be clarified. And so in both elements, both in terms of the National Assembly, the Speaker, as well as the Constitutional Court, I think it requires that going forward, they need to be a lot more meticulous. And today they could have been more meticulous on the main course of action of the UDM, that it is not under any circumstance their privilege to direct the National Assembly on how to make the rules.
All right, we're going to leave it there, gentlemen. We hope we covered all the angles and aspects to satisfy our viewers, but it has indeed been a pleasure. Adil Nchabeleng is Transform RSA President. Joining us in studio, political analysts Tsepo Khadima and Botsang Moilwa, Mr. Carl Niehaus, MKMVA NEC member via Skype, and Mr. Marinas Vickers is a constitutional lawyer, and you at home, as always, much appreciated. We take